Hi everyone, Jennifer Schaus here. We are coming to you live today from Washington, D.C., and thank you for joining us in our sponsored content webinar. Before we dive into today's discussion on navigating the current regulatory changes, I'd like to introduce our partner for this session. FARSITE is a compliance automation platform built specifically for government contractors who need to stay current with evolving FAR requirements. The FARSITE platform automatically tracks regulatory changes, provides compliance guidance for every clause, and generates accurate flowdown lists. These capabilities are valuable and essential as contractors manage existing requirements and new regulatory guidance. Chris Cook with FARSITE will walk us through practical strategies for maintaining compliance in your government contracts. Chris, over to you.
Thanks, Jennifer. Appreciate the introduction, and thanks to all of you for joining us in today's webinar. One administrative announcement before we get started. If you have any questions throughout the webinar, please feel free to type those into the chat box. It should be on the right side of your screen. There's a drop-down box next to the To label, and you can select organizers and panelists, and we'll monitor that chat box throughout today's webinar. During the session today, we'll discuss the Revolutionary FAR Overhaul, including the steps that the government's taken to date. We'll also discuss what we expect to see over the coming months and even years as this massive change ripples out across the government's procurement activities. And we'll discuss what these changes might mean for your contract review, compliance, and supply chain practices. But first, let's step back a bit before we dive into these topics. Quickly, just a little bit about me and our organization. As Jennifer said, I'm Chris Cook, CTO with FARSITE. We're a SaaS platform dedicated exclusively to compliance with the FAR, including the DFARS and agency supplements. And all of our clients are US government contractors, large and small. They range from aerospace and defense to construction to AI, really across all industries. And our customers rely on FARSITE to ensure compliance with the FAR, and they're already using it to stay ahead of the FAR 2.0 changes that we're going to be discussing in today's session. So let's dive right in. Earlier this year, the Trump administration issued two important executive orders that will be at the heart of today's presentation, and we'll discuss in greater detail in the slides that will follow. These two executive orders, and in particular, Executive Order 14275, launched the Revolutionary FAR Overhaul, or FAR 2.0 as we're calling it. The goal of this overhaul is to streamline and simplify the government's procurement, including by rewriting all the FAR parts. The executive orders push for speed, requiring the rollout over a very, very short period of time. Unfortunately, with so much change taking place so quickly, the transition during the short to medium term is likely to be bumpy and cause some confusion not only for contractors, but potentially also for federal agencies and their contracting officers. Executive Order 14240, titled Eliminating Waste and Saving Taxpayer Dollars by Consolidating Procurement, it seeks to consolidate federal procurement in the General Services Administration, or the GSA. This EO focuses on common goods and services, a term that'll be defined by the Category Management Leadership Council, which is led by OMB, or the Office of Management and Budget. The executive order also requires the administrator to rationalize government-wide procurement and definite delivery contract vehicles for IT procurement across the government. It's likely to cover IT hardware, software, and even cybersecurity procurements. The executive order requires all agency heads to submit proposals to the administrator of the GSA regarding domestic procurement of their common goods and services, that administrator will then in turn submit a comprehensive report and their plan to the director of the OMB. Next, Executive Order 14275, titled Restoring Common Sense to the Federal Procurement. Now, this truly kicked off the FAR overhaul process, and it requires, quote unquote, comprehensive reform of the FAR. Within 180 days of this executive order, and by that I mean October 12th, of this year, the administrator of the Office of Federal Procurement Policy, or OFPP, in coordination with the FAR Council, the heads of agencies, and others, has to amend the FAR to ensure that it contains only provisions that are required by statute or that are otherwise necessary to support simplicity and usability, strengthen the efficacy of the procurement system, and to protect the economic or national interests. In addition, it requires that agencies align their supplements to the FAR, and they designate an official to work with OFPP and the FAR Council to accomplish this priority. The EO requires that the director of OMB issue a memo, which I'll discuss later, that provides guidance to agencies regarding their work in this initiative, and it directs OFPP and the FAR Council to issue deviations or clause deviations and interim guidance until the final rules reforming the FAR are actually published. And lastly, this executive order requires OFPP and the FAR Council to identify all provisions that are not required by statute, but that will remain in FAR, and then to consider amending them by adding a 4-year expiration date, also known as like a sunset provision. Now, this last point, by the way, is already raising complicated questions for contracts that will contain these types of clauses. We'll talk about that more in just a few minutes. So to reiterate, the government stated goals of the FAR Overhaul, or FAR 2.0 as we're calling it, are to retain only those clauses required by statute to the maximum extent possible, to reduce the regulatory burden on contractors, and to do so while protecting the government's economic and national security interest. Of course, many are concerned about the scope and the pace of these changes to come, and we've got some recommendations for that here in just a few minutes. Next, I want to turn to OMB Memorandum M2526. On May 2nd, OMB issued this memorandum required by Executive Order 14275. It says that the FAR will be focused on its statutory roots, and most non-statutory regulations, I should say, will be replaced by OFPP endorsed buying guides that will highlight proven innovation buying techniques for different phases of the acquisition lifecycle, as well as solution manageable procurement pathways for different types of common goods and services recognized by this particular category. You're not sure what all this jargon means? At this point, neither are we. According to OMB, the buying guides will be living documents that are updated as best practices evolve, and they'll accommodate varying levels of procurement experience. The good news is that these buying guides will be non-binding and they'll just be guidance. The May 2nd memo also mentions the regulatory sunset provision, and the FAR Council promptly issued it at FAR 1.109. On May 2nd as well, the FAR Council issued instructions to agencies that are subject to the FAR to support their issuance of FAR deviations to implement the executive order on restoring common sense to federal procurement and OMB's memo overhauling the FAR. So let's get into that a bit. In summary, the FAR Council says that agencies should generally issue agency-specific class deviations within 30 days after the FAR Council's class deviations were published on the Revolutionary FAR Overhaul website, and that's available at acquisition.gov. Agencies should then ensure that their class deviations are disseminated throughout their contracting workforce. They should also use the FAR Council's class deviation text in their agency class deviations. And if they do so, they don't need to coordinate with the FAR Council. However, agencies must request approval from the FAR Council before issuing the Revolutionary FAR Overhaul class deviations that use text that's different from what the FAR Council's class deviation text has published. Now, the one exception is unless the difference is necessary to address the agency-specific statutory requirements, then they're accepted. The FAR Council will review and provide a decision regarding the agency's alternate text within 5 business days of the receipt of that request, if not sooner. An interesting point here is that if the agency doesn't receive a response from the FAR Council, the agency is permitted to proceed. During the Revolutionary FAR Overhaul process, agencies have been directed to limit the issuance of class deviations that are not related to this FAR 2.0 process. A little bit about the timeline here. To recap, the White House issued its executive order launching this FAR overhaul process on April 15th. Both the OMB and the FAR Council issued their memoranda providing instructions to agencies on May 2nd, and on the same day, the FAR Council started issuing class deviations as well. Agencies will have 30 days to issue their class deviations from the date that the FAR Council's text is released. Now, I want to pause here and just add one more reminder. If you have any questions about the content that we've discussed already or we will discuss, feel free to add those into the chat box. On the right-hand side of your screen, you'll see a chat box with a drop-down box where you can designate that your chat should be sent to the organizers and panelists, and we'll try to cover that as we wrap up today's webinar. Although FARSITE's not a law firm, and we always inform our clients of that, we don't provide legal advice. We encounter many questions about the FAR 2.0 or the Revolutionary FAR Overhaul and what it's likely to mean for government contractors. In general, we interact with company legal, compliance, and contracting staff, and they've all asked us, what does this mean? What should we expect? And essentially, we tell them to get ready for change. Even in this technological age, the vast majority of companies, and not necessarily our clients, of course, still use manual processes to review the clauses in their solicitations and contracts, such as FAR clause checklist, maybe spreadsheets. Clients come to us when they've relied on their historical knowledge or knowledge of their staff, general familiarity or experience with determining whether a FAR clause is applicable or maybe not, and whether it's acceptable to their organization in the context of a given contract, or if that clause might require further review, approval, validation. They rarely undertake the tedious task of double checking the prescription text and the Flowdown rules for each and every clause to determine whether those clauses should be in their contracts even in the first place. And when clients come to us, they don't always have a system in place to ensure that members of their staff and their functions across their organization are uniformly or consistently following an approach to comply with particular clauses or obtaining approvals. We often counsel clients that these habits and practices could expose their organization to financial or complicated risks, both prior to this FAR 2.0 process, but also after FAR 2.0 begins. A little bit more about FARSITE. FARSITE's a software as a service platform, as Jennifer and I explained at the beginning, and we maintain a database of all FAR clauses, including DFARS and every agency supplement. That database includes old clauses, new clauses, deviations, and even the deviations that will come in the RFO or FAR 2.0 process. Our clients simply drag and drop their solicitation or contract, just like it comes from the government, directly into FARSITE, and then FARSITE immediately gets to work. For example, it applies the government's prescription rules, and it flags clauses that shouldn't be in the contract in the first place based on the contract type, the contract value, and other applicability rules. When you're performing as a subcontractor, FARSITE's smart, it knows that, and it applies the Flowdown rules that apply to your contract instead. It even generates Flowdown lists that you can use with your own subcontractors. And FARSITE knows when you're encountering a clause that your organization has never seen before. It might be a brand new clause. It might be a deviation that's been generated through this FAR 2.0 process. FARSITE will flag that for you, and it will help your organization create a track changes style comparison between any two clauses so you can quickly and easily see the difference and understand the implications for your organization. These are just a few examples. FARSITE is feature rich, but at its core, it replaces manual, tedious clause-by-clause review processes, and it helps you be prepared when the government issues class deviations or new clauses for how do these deviations differ from your existing compliance practices, and what, if anything, should you do to accommodate these new clause changes. We also work in collaboration with Kroll and Mooring, one of the nation's leading law firms, particularly in the area of U.S. government contracting and compliance. Together with Kroll, we maintain plain English compliance guidance for every clause in the FAR, including agency supplements and deviations. This guidance is broken out by business function. Essentially, what should organizations do to comply with these clauses? That guidance also includes what to do to comply with the deviations that are released as part of FAR 2.0 or the overhaul process. We host this library in FARSITE, and many of our clients use our compliance and contract notification and approval workflows to disseminate or communicate this guidance out to various members of their team and to obtain and document compliance certifications and contract approvals, even down to the individual clause level. So in other words, FARSITE not only rapidly evaluates and processes FAR clauses for applicability, but it provides compliance instructions and enables you to hold your employees accountable. FARSITE was originally designed by lawyers and compliance professionals in consultation with contracts managers. They were tired of manually reviewing large numbers of FAR clauses that appeared in every solicitation, figuring out, is this the current version of a clause, or does this deviation override certain things that we already have in place? Not to mention the overly comprehensive, the dreaded Flowdown list that you get from a higher tier prime contractor that includes every FAR clause, relevant or not. So they built an automated tool to process that, and their work ultimately resulted in a tool we now call FARSITE that's used by U.S. government contractors, both large and small, across many different industries. FARSITE's quite literally been used to screen thousands and thousands of contracts, and happy to share more information about that with you today. If you're interested in learning more about FARSITE, or if you have questions about the Revolutionary FAR Overhaul process or FAR 2.0, we encourage you to visit us at far.site, www.far.site. You can sign up for a demo if you're interested in the product, or if you have any questions about today's webinar, feel free to put those in the chat. And now I'd like to just review some of those questions and see if we can answer questions for the audience, either about FARSITE or about our view or what clients are coming to us with questions about FAR 2.0, the pace, the overhaul process in general. Pause just 1 second, review those. I see a question about whether the FAR Council is going to meet the deadline of October 12th. It's a good question. We just don't know at this point. Obviously, as I've described, I think this overhaul process is a lot of work. Those of you that work day in, day out in the FAR, you know that it's quite complex in the drafting process, and the government's committed to such a short time. I think that it's further complicated by this process that the government's announced, where agencies are also going to have to be issuing deviations, and the agencies are going to have to evaluate whether those are consistent with the FAR Council's class deviations, or they're going to need to issue supplemental deviations. So I suspect that process will take some time. Another question about the deviations the government's already issued, where those can be found. We've seen already the government has released deviations to various FAR parts, and all of those are listed on acquisition.gov. I think it's acquisition.gov/FAR-overhaul, or the link is accessible on the main website of acquisition.gov. Unfortunately, for most contractors, keeping up to date with that is a challenge, but you can manually review those there on the website. FARSITE does have those automated, and they're automatically in our database, so you can our customers can access those deviations there as well. Another question about the rulemaking process, the length of that. I've not seen any indication that the government's going to take a different process at the end of October for the rulemaking of the actual FAR clauses. We expect it will follow the formal process defined in the statute, and it will go through the normal comment and publication period. I mean, depending on the volume, I think it could take some time. as we've seen in the past, but this administration has been committed to expediting this process, so it might be speedier than we've seen in the past. Just looking through other questions. If you have questions, feel free to write those into the chat box, send them to the organizers and the panelists. One question asking, since the government's really doing this to try to reduce complexity, isn't it going to be easier over time to ensure compliance? That's actually a good question. I think in theory it makes sense, and in the long run, I know that most of you as government contractors are eager to work with a FAR that's easier to manage, easier to read, easier to understand, and ultimately easier to comply with. From my perspective, I think there probably are a number of countervailing factors that might complicate the situation. I think that there are circumstances where there may be contracts that may contain a mix, some of the old clauses prior to the overhaul, and then either deviations or new ones that are simplified after the rulemaking process begins. So that complication will require contractors to maintain either a database or a tool or some process to keep those separate and clean. I also, I'm thinking that contracting officers or government procurement writing systems, contract writing systems, if those don't keep up and are up to date, there may be challenges where in the initial contract writing process, contractors see clauses that don't reflect the current deviations that have been published either by the FAR Council or agency supplemental deviations. In that same vein, I suspect that higher tier primes, if you're a contractor that is primarily a subcontractor, I suspect there will be some lag between the time when the larger primes have updated their FAR Flowdown list that they're incorporating into subcontracts. We don't provide legal advice, but as many of you are aware of this concept of the Christian doctrine, I think contractors should be careful of ensuring that they're reviewing what should be applicable in their contracts and subcontracts. One other thought here on this question, just to round out this answer, is that I think that contractors may also expect a higher number of modifications to existing contracts once the deviation process begins, and in terms of more deviations on the provisions and clauses in Section 52, and then even as the rulemaking process rolls out. Lastly, one question about, are there any challenges to this process? I think that from a government contractor's perspective, what we're hearing from many of your peers is that they're all excited for this process. Anything that's going to simplify the acquisition process by the government and then ultimately make it easier for contractors to comply, that's welcome news. But there's a possibility of litigation or interest groups that are going to challenge elimination of maybe regulatory provisions or FAR clauses that weren't defined by statute, but that align with their interests. That's not something that we've seen take place yet, but it's definitely a possibility, and I think the rulemaking process will take some time. I want to be sensitive to everyone's time here. We really appreciate your participation. If you'd like to know more about FARSITE, you'd like to see a demo, we'd be happy to host a demo for you. Visit us at far.site and you can request a demo on the website. If you have any questions about today's webinar or the FAR overhaul itself, we'd be happy to share feedback on what our clients are doing to stay ahead and prepared for FAR 2.0. You can reach out to us at support@far.site or contact us by visiting our website, far.site. Thank you to Jennifer and her team for organizing this webinar, and thanks to all of you for participating in today's session. Appreciate your time and have a great afternoon.